5 seconds to go. Start. In the instant case, the National Commission itself had exceeded its revisional jurisdiction by calling for the report from the respondent bank and solely relying upon such report, had come to the conclusion that the two fora below had erred in not undertaking the requisite in-depth appraisal of the case that was required. Stop. In the opinion of the court, both the State Commission as well as the Consumer Forum had elaborately appreciated the documents on record and passed the reasoned orders. Stop. The report that tries to absolve the respondent bank of its liability is based on surmises and conjectures, as it abstrusely and without evidence holds that the bank has every reason to believe that wrong account number was intentionally inserted by the appellant himself for reasons best known to the appellant, or on account of negligence by the appellant by not keeping the passbook in his safe and proper custody. Stop. The suppositions are contradictory as well as incredulous and fanciful. Stop. The appellant did not know the second respondent and would not have known his account number unless given to him by a bank officer. Stop. There was no way that the appellant would have known that the second respondent, namely Sunil Maity, had an account in the same branch. Stop. No sane person would deposit cash or check meant to be deposited in his account in an account number belonging to another person with similar name. Stop. On the other hand, the bank should have been extra cautious given the fact that accounts of the appellant, Sunil Kumar Maity, and the second respondent, Sunil Maity, were with the same bank branch. Stop. What is rather surprising is that the National Commission, for setting aside the findings and conclusion recorded by the District and State Forum, simply reproduced the report by one of the officers of the party in litigation with the appellant. Stop. The National Commission has not adverted and delved into the sound reasoning given by the State Commission as quoted above. Stop. Para. Though a party can produce additional evidence at the appellate stage, the same has to be within the four corners of law, that is as contemplated in Order 41, Rule 27. Stop. The party has to establish that notwithstanding the exercise of due diligence, such evidence was not within its knowledge or could not even after due diligence, be produced by it at the time when the decree appealed against was passed. Stop. Apart from the fact that there is a vast difference between the exercise of appellate jurisdiction and the revisional jurisdiction, no such application was filed by the respondent bank before the National Commission. Stop. Under the circumstances, calling for the report by the National Commission on its own from the officer of the bank was absolutely unwarranted. Stop. Para. Further, it is also well settled legal position that requirement of leading detailed evidence could not be a ground to shut the doors of any forum created under the Act like the Consumer Protection Act. Stop.